It takes a lot of time to do that, so you kind of want to do it periodically, maybe daily or once a week, something that'll do that, because otherwise it takes a lot of time for you to download those type of things. Okay.
Did everybody sign in?
You must scan in.
And then there's 2 here, and there's another one.
Great, thank you. Real quickly, I want to tell you about, I was at the Texas Association of Realtors, the Texas Realtors Group, during the winter meetings. And I attend, because I'm on the professional standards, I attend the Code of Ethics training every year. It's a 6-hour course. And which article do you think is most violated by Texas Realtors out of the Code of Ethics? And I know you all read it every day. Just guess. You don't have to name the article. You can just tell me what you think is the most violated Code of Ethics. No. Advertising. Amen. I can tell you that because I drive a lot around Houston, and any given day I'll see a sign and I'm thinking, wow, that looks like a Keller Williams sign, right? And I'll get up because I'm stopped in traffic and I'm getting closer to the sign, and I can't even tell which brokerage it is, and I work for all but 2 of them here. I recognize the agent name, but I can't tell the brokerage. And that's because Article 12 is the most violated. And we have to portray a true picture in your advertising materials. This includes online content, social media, images, and domain names. What does that mean? It means that you can never have a name that looks like you are in charge. Okay? The other thing is ensure your status as a real estate professional is readily apparent, and disclose the name of your firm in a reasonable and readily apparent manner. A team name alone is not enough. You know, you're never alone on something like that. So that's what is so important on that. Okay, what we're going to do today is, as I said, this is going to be a 2-parter. And my biggest concern for you as a buyer's agent is that the buyers are coming from a standpoint where they don't know very much, right? They only know what they want to buy, what they want like in the house, and those type of things. When we work with sellers, we're relying upon sellers to tell us a lot of information. So you see how different it is? The transactions are totally different. The problem for you is that you have tremendous liability when you represent buyers because of that, because of their lack of knowledge, experience. And so what I'm going to go through today, we'll be reviewing all of the areas where we have found over the years have caused agents difficulty in disputes, and I want you to remember to avoid them. And so that's what we're going to do. The first thing we're going to go through again is, it's going to take a little time, but it's the proper way and when to complete the IABS and any representation agreements that we have. The representation agreements are very important. Your broker requires them, and you satisfy your code of ethics because it says that you will never, ever do anything with your client unless you've reduced it in writing. So if you do it like right before you're going to want to get paid, that's not how you abide by the code of ethics. It's done at the proper time. The second thing is what you must tell a buyer that you're representing if they're interested in a type of property by the transaction. And we'll go through a bunch of them. There are lots of issues and lots of red flags that come up. And even though you may not have had experience with this type of transaction, you're going to know that, oh, I need to stop and kind of advise them properly. That's your job, is not to make decisions for them, but to advise them properly, give them options. Then they get to make the hard decision. But whatever you advise them, you have to do it properly and correct. Next time, we'll probably get to the general information and notice to buyer and seller and what to highlight. Notice I said what to highlight. That's because these are our association forms. They are not promulgated. TREC does not provide us any private agreements. And so we're able to take our association forms and highlight them, have our clients initial by there so that it proves what? That you reviewed it with them, that you brought it to their attention. It popped off the form. It wasn't just something shoved to them and say, please initial sign and date. That's your biggest issue, is that you have to prove that you actually review these documents with your client, not just get them to sign them and those type of things. Then we're going to go through some steps that you need to do In the event your buyer is acquiring a property where there is a tenant in the property and a lease will be conveyed to your buyer who will become a landlord at closing and funding. We've had a lot of agents get in disputes over this because where it is in the contract, there are no fill in the blanks. So nobody's really read what the seller / landlord is obligated to do, and I don't want you to get in trouble for not watching out for that. Then we're going to talk about perfect your skills on assisting clients with amendments. In our contract, for the most part, we fill in the blank or we check boxes and add days. In special provisions, we got a little area where we get to write something, but not much. Those are only material facts or statements. Where you get into the serious trouble is trying to write an amendment that the buyer wants to present to the seller to agree to a condition of property maybe, or some other provision. And it's up to you to make sure that you do that perfectly, because that's where you're going to be judged on something. Case in point, we have a transaction. This agent worked with these buyers over a year. They couldn't find what they wanted when they sold their home, so they went into a 6-month lease, and then they started the search after that time. So she had a tremendous amount of text messages because they never used email. I mean, hundreds upon hundreds of text messages. And what had happened is she did the right thing. She asked her buyers, you know, after your inspection, what do you want to ask the sellers to fix, repair, treat, whatever, right? And the buyers sent back an email that was really beautiful. It was 1, they wanted that, 2, 3, 4, all those things. Well, what happened to the buyer's agent is I think they wanted to kind of clean it up a little bit, and that was their first mistake. When they cleaned it up, they did not transfer exactly what the buyer was asking the seller for performance. And so we get into trouble many times when we don't really know what they're doing. Another agent called me on the way, and I've told you this as buyer's agents. If your buyer wants the seller to do something, they're going to reduce that in writing on an amendment, right? And the reason for that is the agent said, well, I just wanted to, the listing agent wasn't timely in the response, and we just wanted to know what the way the seller wanted to go, and we wanted these things done. Well, you're taking a huge risk because what? You are interpreting what the buyer wants. There's no amendment where the buyer has signed it. Yes, they have to read it and they're charged with reading it, but if you didn't transfer something perfectly, you could be responsible for that. But bottom line is buyers need to sign an amendment. That's the only way they're going to communicate what they want back to a seller. Otherwise, it's the agent interpreting what they want or the conversations. And that's where you get into trouble a lot of times because you might miss something, you might leave something out, or not realize what was conveyed to you and you missed something. As I said, amendments are a fine art in both any practice of real estate, any specialization. It truly is important. And the last thing we'll go through next time is documentation and how important it is not only to you, but to your clients as well. You have to have a clarity what they want you to do. And if you're texting, we found that in our legal battles, text never was sent the way it wanted to be received. The receiver didn't see it the same way. It was taken out of context. It was abbreviated, all these different things. So we'll talk about how the best way for you to probably document if you rely upon text tremendously in the course of the transaction. Okay. When do you give the IABS to your prospect? First communication about real estate, right? Well, it was interesting, not this general counsel, but two before, Carrie Lewis, she had a YouTube video, and she used the word, when you start talking about property. And I thought, well, that's because she doesn't think any of the agents know what real estate is. But really, she wanted to kind of get it down to the basic. The minute you start talking about property. Yes? In an open house, in the event you are not the listing agent, you would probably identify who you were, that you're an agent under the same brokerage hosting this open house. Your premise when you are an agent hosting an open house is everyone who walks in is going to think you work for whom? The seller. That's an understood type of thing. And you do as a host of an open house. Even though you would love to procure all these buyers, right? Your premise is, I'm only here because I represent the seller in making sure I host this open house. No, you don't have to give them the IABS at that time because you're just talking about the property that you're hosting. Yeah, well, that's what we do when we host an open house. Then you're going to say, and this is what you say, oh, I would love the opportunity to represent you. I'm here today till this time. Give me a good number so I can contact you when I'm finished. And that's how it works. We're going to talk a little bit about surveillance. Everybody does know you're being surveilled every time you go anywhere inside a property, just so everybody kind of understands that. So again, the deal that the law states is that it has to be delivered. Can it be blank? How about if we just fill in the top line and maybe our information? No, it has to be completed, totally completed. There will be no blanks because what Trek felt the consumer needed to be able to contact anyone that might be responsible over your actions. That was how they felt that was the fairest way, so the consumer knew how to get after you about 4 different ways. And so that's why all that information was there. So again, you have to have proof that you delivered it. Have you ever had a prospect that says, I'm not going to initial and date that? Yeah. That would be somebody I would never work with. If they can't stand information, good luck on what you're going to have to get them to sign the rest of the transaction, right? So again, it's just information, and it's a requirement of law. It wasn't Keller Williams who made this up. This is a requirement of law. So anybody who won't just initial and date it, that's a pretty sad thing. But again, your duty is to deliver it, to prove delivery so that you could say, hey, I did deliver it to them, right as we were talking about real property, real estate, those type of things. Yes? Yeah, we'll get to that in the training because that is very much part of the buyer-tenant agreement as well as in the listing agreement. At this winter meetings, we had a guest speaker who probably could have gone on for days. He's a specialist with surveillance and investigation. And he talked about Texas is a one-party state in this, but all sellers who record when they're not there, it's against the law, and that's why they tell them in the listing agreement as well as in the buyer-tenant agreement, and we'll go through that in the buyer-tenant agreement. The problem for somebody that has the Ring doorbells, and what he did is he showed us a graph of all of the police stations that are going to homeowners in certain areas and giving them a free ring so that they can do what? Cooperate with accessing information. The problem is we either have to present knowledge to somebody that they're being surveilled or get their consent. Okay, and that's the big thing. And so anybody who has any kind of recording device that's outside, wherever that view is, those signs will be posted maybe from the curb, maybe when you turn, and the doorbell will pick up your video and that. But the obligation is on the homeowner for that. As a buyer's agent, we're going to talk about it in the buyer-tenant agreement, but every buyer needs to know they're being recorded. It's in our additional notices, so it's something that you're going to review with them anyway on something like that. No, that's different. Surveillance is where the homeowner may have audio and video surveillance equipment looking at what you're doing. And while we know that's not acceptable, they do it. So that's why your buyers need to know, and you do too. on something like this. Okay, on the buyer-tenant agreement, it is a broker's requirement, and part of that is because the broker complies with the code of ethics as well. We reduce everything, every agreement we have with our clients in writing. The biggest thing is that sometimes you tend to not place much importance on this at that point in the transaction, but because intermediary can never be implied, we have to have it in writing from the buyer if they will allow the broker to become an intermediary or not. You must have that in writing. Intermediary is never implied, it's only in writing. We have it in the listing side, but you as a buyer's agent have to make sure you secure that. And for example, if you were an agent who was getting an opportunity call and they said, I saw your sign out and I'd like to see that listing, and you're not the listing agent, who would you represent when you showed that property? The seller. And you're never going to get paid. Okay, so I don't know about you, but last month I mentioned that you are a profit center. Your goal is to keep your profit. I don't mind you volunteering at a nonprofit, giving your time and talent and money to a nonprofit, but you are a profit center. So the reason you're going to do these things at the right time is because you want to secure what? Your compensation, exactly, for something like that. And besides, complying with intermediary is very important to make sure that it's done at the right time. So now we're going to pull up a buyer-tenant agreement. Oh, let me do that real quick. Where are you? I know he had it here. Here we go. Okay. Everybody familiar with this form? I don't think I'm going to need to go through parties. Everybody understands who the client is and who you are, okay? Notice the first highlight that I did. Again, these are your forms. You can highlight and have anybody initial it and bring it to their attention. But on paragraph 2, it's only one sentence long, and it says, client grants to broker the exclusive right to act as client's real estate agent for the purpose of acquiring property in the market area. There's two things on here. The word exclusive, yes, market area is the other. But exclusive is the first one. And what does that mean? That means when the buyer has signed an agreement with you, they can't go across the street to another brokerage and engage in other representing them. This is what it does. It binds them. And I don't know about you, but if somebody doesn't want to commit to you, you don't want to commit to them. I mean, that's just kind of a basic. But the other thing is it mentions an area, it says market area, that's forward and is an actual provision in the buyer-tenant agreement. And market area is very, very important. And you better complete it properly because that's really what is going to be so important. It's in paragraph 3C. It says that the market area means that area in the state of Texas within the perimeter boundaries of the following areas. Never use the word Texas. You don't have permission. Your broker has to give you a test now if he's going to allow you to practice real estate in an area that is not a part of your normal market area. They have to do a test to determine, do you know the economics of this area, the zoning, all of the statistics that involve housing. TREC made that very clear in 2018 that you just don't get the privilege, even though you have a license to practice real estate in Texas, your broker has to give you written authority to leave your area of expertise, an area that you're very involved in. Never use the word Greater Houston area. When these agreements have been tested in court, the brokers that lost were the ones that used the word surrounding areas and those things. And what the court ruled was that the buyer has to know clearly what are they obligated to. And the word surrounding is not defined. Greater Houston area is not defined. What we find is that the word that's really good can be counties. Counties are public record. They're not subject to us changing them, the boundaries. Anyone will be able to see them and find them. And so if you were going to use Harris County, you'd say Harris County. If you were going to go into Fort Bend County, it'd be Harris County, Fort Bend County. Wherever you're going to be going, you're going to specifically identify the county. It's the easiest way to usually do that. Now, sometimes we have investors that work with agents from all over the city and the surrounding areas, okay? So they'll have an agreement with you that may be tied to zip code, could be tied to a development, right? Because the investor says, you know, you're the specialist in this area, so I'm going to tie the market area with my agreement with you to this subdivision. I've got another agent in Sugar Land that does Sugar Land for me. Do you know what I'm saying? So we have sometimes where an investor will have multiple agreements, but your agreement's going to be tied maybe specifically to an area, perimeter, that they've given you notification of. We do have that. Now then we have some buyers who say, I don't sign these agreements. You know, and we had one this past week that said, if you did your job better, we would never have to sign these agreements. I thought that was pretty horrible, personally. I really do, because they don't know anything about the code of ethics that we take. Our buyers and sellers don't take a code of ethics. Let me let you know that right now, but we are bound to it always, right? So on something like this, you're going to say, well, I do want to comply with the code of ethics that I take. See, I take the code of ethics and it says I'll reduce everything in writing. So now, because we're going to put an offer in on this property, market area will be only to this property. You're not bound to me on anything else. Okay? And so we do that a lot of times. I am going to tell you there are relocation companies where buyers are being relocated and the relocation company tells them don't sign anything from the brokerage. Well, here's what you can do. You can provide it all to them and say, even though you've been instructed not to sign them, you have possession of them, and we will abide by the tenets of each one of these agreements. You can do something like that, and you could prove that you delivered it to them. They're the ones that just didn't sign it, but you're going to state, but we're going to abide by all of the provisions of them, okay? So sometimes we just have to figure out a way to get this secured in writing. It's really important. Now, what we're going to do is go down to paragraph 5. It says broker's obligation. Well, there's 3 things in this sentence. It says, number 1, we are going to try and find you a property in the market area. So it's pointing back now to that paragraph 3C. Second thing we're going to do is we're going to help you acquire the property in the market area, negotiating for you, right? So we can get you under an executed contract. And then the last one is very broad. It says comply with other provisions of this agreement, which basically it's really broad, which means you're always going to do the right thing. It's in their best interest and that type of thing. Now, the client's obligation, remember they have that exclusivity with us, right? Well, the thing that I find that they really need to pay attention to is inform other brokers, salespersons, sellers, and landlords with whom client may have contact that broker exclusively represents client for the purpose of acquiring the property in the market area, and refer all such persons to broker, real important, and comply with these provisions of this agreement. Well, what does that really mean? Well, you have to have a little bit more conversation, and I'll show you a way that you can add this in special provisions of this agreement. But you really need to be letting the buyers understand that, look, you can't ever call another sign anymore. You call me first and give me the property address, then I'll get all the information for you. You can't go to a builder directly without me, okay? If you're going to go to an open house, please let me know the open houses so that I can make sure I register and let the host of the open house know that my client will be coming, okay? So there's all these things that get the buyers into trouble. They're just thinking they just want this house. They drove down the street and said, I don't know why our agent didn't give us the MLS on this, and they find out they call and they find out maybe the sales price or a list price or something like that, or what's the status. And the next thing you know, the person who picked up that phone is trying to talk them into what? Working with them. So again, your buyers really need to understand that it's in their hands and they have to do certain things, and it's always coming back to you, asking you to find out more information. They're not going to pick up and contact a party directly, because it could cause problems with the fee that we receive, and that's in paragraph 11. And again, you're a profit center, right? Okay. The next paragraph that we're going to go through is the intermediary. Oops, how do we get here? Not that representation is not important, but intermediary is. This is the one that I mentioned, one of the big reasons we have to get this secured in writing. Can you show a listing of this brokerage if you don't have intermediary marked? No, you cannot do that. And there are some buyers who don't want to be shown properties that are listed by this brokerage. That would be foolish because of your market share, but you never know, right? And they would mark no intermediary status, which means you don't get to see any of these listings. I'll never show them to you. I won't give them to you for prospects. Even though it matches your criteria, you'll never get it. But we usually have intermediary status marked, and this is where the broker will be the intermediary. An agent that's representing the seller will be appointed to the owner, and then the buyer agent will be appointed to the prospect. And what you probably need to let your buyers know about this is that here's how this works. They have no access to my information about you, and I have no access to their information. We are not going to informally discuss this transaction at all. We have to maintain the integrity of intermediary, and that's exactly what you have to do. You can't just stop in the hall and talk to somebody about that transaction. It would be the same as if it was listed by a RE/MAX agent. Basically, it's kind of how you're looking at it. You're not going to have these casual conversations, because the minute you do, one party's going to think you're colluding with the other party. Do you know what I'm saying? That's kind of how they feel sometimes when they feel you might be sharing something with another agent and not in their best interest. But intermediary is very, very important. It's something that we have to protect. The legislature back in 2005 allowed us to conduct at a fiduciary level. Prior to that, we were not at a fiduciary level if we had this situation. Okay, paragraph 9, competing client. Yes?
So if I do an open house that side of the what their goals are, making my client
That is an intermediary when you represent the buyer, and
because I've already
you have confidences all the time. Unfortunately, y'all don't know what confidence means in keeping things confidential. Just because you may have knowledge about it, you cannot share that with your new client. Nothing can be shared that would give one advantage over the other party that is represented by the broker. So we don't share anything that we might know. When I had my team, they were never privy to my client folder that had my net sheets and all the other information. I would never, ever share that with a host of an open house. That just is common sense. Yes, sir.
So, Marilyn, separate.
Well, they're called a customer, that buyer. They will never be represented because you only represent the seller. I can't buzzsaw you in two. So at that point in time, if the buyer says, and we've offered to appoint another agent to assist them, since we want to make it very, very clear, we give them the IABS and the Texas Realtors 1417, which is a representation disclosure that says, I work for the sellers, I name them, and then the customer signs and dates that. Well, at that point, the broker is the only one that can vet it and determine that intermediary will go forward with no appointments. But you really need to receive in writing, both from the seller, understanding that I can give you no opinions and advice from this point forward, and that the buyer also knows that in writing, and then they come back. I'll be honest, every time a seller has been explained this, they go, well, why do you think I'm paying you? I'm not going to let you do that. They do. And we've had a situation where the seller felt that the listing agent favored that buyer over the, it got into a huge conflict on something like that. Yes. Are you the listing agent? No, I was doing it. Okay. How did you know the last contract?
Well,
Okay. Correct. Yeah. Yes, ma'am. Well, probably because we have a lot of social media that is out there that says, represent yourself and get the other broker's commission. There is so much of that type of thing going on, but I do understand what you're talking about. Right. Well, the problem for listing agents, and I talked about this last month, is paragraph 5 is all the listing brokers. We just say we'll cooperate in the event there's another broker involved, right? But it's always our compensation unless we cooperate. Okay, and so yeah, I think it's real important. What we have found is that sellers, once they know that the agent says, oh, we're going to do no appointments because I represent this buyer under a buyer-tenant agreement, I represent you under the listing agreement, and then they find out that you're no longer going to give opinions and advice, that's usually when they don't like that. And that's a fact, and I understand that. My thing is, agency is precious. And agency is the only reason you get paid is that you represent others in a transaction. But to put yourself in the middle with no appointments, you are running a huge risk because many times you're asked opinions by that party and you kind of forget that, and you might cross that line, and you cannot do that because that would be favoring one party over the other. See, the broker is able to become an intermediary and stay neutral. They're never going to favor one party over the other. It doesn't mean that the broker doesn't understand things. Oh, they do. They have absolute clarity on your situation and what you're going through. But it's really difficult for one party to feel that you treated them fairly, but you probably help. You know what I'm saying? We get them all the time. They don't like the amendments and you're the only agent, so you're the only one facilitating that back and forth. But competing clients, here's what it means. This is a broad statement that the broker makes. And the broker is saying, look, you acknowledge that I might have other clients interested in the same properties that you're interested in, right? So at this point in time, the broker makes a very large statement, and it's broad because it's going to be factual. any given day, you could have 25 agents show the same property, right? So what happens to you is if this paragraph now that was very broad, that was just language that the broker was telling your client, now it comes down to your level. You actually represent two buyers who are interested in the same property. And this is the process that you have to follow, and you have to do it very well. And it will be summarized in writing. But you're going to go to the buyer that you have the buyer-tenant agreement with first, right? First in, gets served first. Okay. And you're going to go to them and you're going to say, I need to let you know, remember that competing clients that the broker statement was in our buyer-tenant agreement? Well, now it is down to my level. It affects me. I have more than one buyer interested in the same property. So I'm coming to you because you're going to get to make the decision how you want me to proceed. Do you want me to proceed forward representing you, and then the broker will appoint another agent to represent my buyer just for that one transaction? Or are you going to give me permission not only to represent you and present your offer, but also represent this other buyer at the same time and present their offer? So they're going to tell you in writing what they want. And what do you think they're going to do most of the time? Yeah, most of the time they're going to say, oh, you can do both, and just tell me what their offer is, so mine is better, right? No, that's not how that goes on something like that. So, yes, I know. He didn't do the microphones, and everybody needs them. Okay. So, again, what you're going to have to do is say, oh, no, that's not how that works. These are confidential. I can't provide any confidences that I have with another client. So, on something like this, that, there we go. That buyer number one gets to make the decision.
Hello?
Hello.
So I had this happen, and I called you in frantic, so this is let all of y'all know. And Marilyn said to me, it is my experience that neither, my client said, we want you to represent us. Mm-hmm. And it was on an expensive house, so I didn't want to give up either one of them. And so I called Marilyn in a panic, and she said, well, you just, whatever she told me, I did. And then she said, it's my experience that neither one of your buyers will get that. And I thought, she doesn't know Cindy Bluestein, not my buyers are going to get it. And sure enough, Marilyn was right. Neither one of them got it. It went for $50,000 over asking.
Well, you know, that happens a lot. I'll be honest. And sometimes the agents call me and say, Marilyn, would you like to know the rest of the story? Yes, I would like to know the rest of the story. And so the agents that do it, they said, I appointed, my friend to do the other. Neither one of them got it. That has always been. And it's something like, there's some karma out there or something, isn't there, when that kind of thing happens? But again, competing clients, most of the time you don't ever review this with your buyers, but you need to, because it could be a potential that it will have come down to your level and will affect them in the transaction. And it's the first buyer who gets to make the hard decision on something like that. There's a microphone somewhere. Where's the microphone?
Okay. The question is, the first client is the one who have to decide if it's okay for you to represent both, but you have to disclose to both of them that you're representing more than one. Yes or no?
Absolutely. Yep. Absolutely. We don't hide anything from our clients. That's part of the code of ethics. Okie dokie. Now, you know how long it takes you to go through a buyer-tenant agreement with your client? A long time. Oh, now we're going to get to my favorite paragraph, broker's fee. I don't know why agents hate this paragraph. I would always want my client to know I don't work for free. And the real one of the benefits is when we have this sign, we can prove that we are due the commission. But what happens is they're not so upset about paragraph A because it's just some fill in the blanks and they're not making any connection to it. But boy howdy, do they read source of commission payment. The first sentence in this paragraph says, hey, we're going to seek the commission from those that, first the seller, landlord, or their agents. Well, that's true because listing agreements give us, as listing brokers, the ability to share compensation with the cooperating brokers. But they don't like the one it's in bold and it's underlined. When those two things happen, it's very important. And so it says, if such persons refuse or fail to pay broker the amount specified, client will pay broker the amount specified less any amounts broker receives from such persons, right? And they go, what? You mean I have to pay you? And they say, can we strike this? Can it be stricken? Absolutely. I told you these are your forms. They could be. The problem for you is if you strike this sentence and they go directly to a builder and you're not on the builder contract, can you go after them for commission? No, you just worked for free all those months or weeks or whatever. The problem too is if you strike this, you better have it somewhere in special provisions that buyer agrees they will contact me first, never go directly to any signage that they see. They will never log into anyone's website and provide information to them. Okay, we've got lots of them who are doing that, so you've got to be specific. You can't go to the builder directly. You cannot go to an open house without giving me notice ahead of time so I can register. In other words, you're going to say that the buyer agrees to do that because that's the only way you really are going to mark this paragraph, the second sentence off, right? Because you're not going to work for free. That's not what your job description is. You are a profit center. But my problem is if you don't tell the buyer specifically, and I mention those websites because let me tell you, a lot of those websites they go to trap them. The next thing you know, they're getting calls. They say, well, I just filled in my email address. You know what I'm saying? All those different things because they're interested in finding out more information. So they have to understand they can't do that. They cannot interfere with our not being able to collect from the right parties, the sellers, the landlords, or their agents. Everybody understand that? Okay. When is your commission earned? Absolutely not. And here's the reason. It is earned the minute you have an executed contract. And then you say, hey, my job's done, yay. No, that's when your work really starts. But the reason it was done that way was it was to protect the brokers. The broker's efforts are to, remember that second sentence and about the broker's obligations? It said what? I'm going to help you acquire a property in the market area. So that's exactly when it's earned. When do we get it paid? At closing and funding. Yes, sir.
So great example on that is about 3 weeks ago, we have an awesome in-house attorney named Hubert, if you haven't met him. It's not always bad to meet the in-house attorney.
Yeah, no.
So one of our agents, Sophia Lombardi, worked very hard with her buyers, and they had a contract with the sellers. The sellers weren't performing, so the buyers did back out, and Hubert was able to, because of their non-performance, go after the sellers, even though a deal never closed. And even though Sophia still has those buyers, she was able to get paid most of her commission to the tune of $7,000 from a demand letter. So it's important that you realize when it's actually earned versus when you typically get it, right? It's earned once you have a consummated contract between two parties that are willing and able to close on the deal. Whether they back out or not has nothing to do with this. And so it's important that you're with a company that supports you in that way. The other agent didn't get paid their commission because they didn't have somebody there to back them up. So really important, you earn that commission, you deserve that commission, you work hard for it. I know sometimes it doesn't look like it, but you work hard for it. By the time you get to the end of the deal, with all that funkiness that happens, you've earned that money.
It's very important that as a listing agent in particular, we have the broker has the authority if the seller's in default to collect it. And it's pretty easy to do that because it's in writing. It's all there in the listing agreement the same way that it is here in the buyer tenant agreement. Do you have the microphone? Yeah.
Did you snag that agent to come to Keller Williams because of that?
We have not as of yet.
Okie dokie. Sure.
Okay, Marilyn, don't yell at me.
Okay.
If I sit down as a seasoned agent and go through all of this stuff, I can just hear, I mean, they just want to see property. So if I sit down and go through all of this and talk about my commission and my way that I do things, I think they would tell me that I'm going to go find another agent.
Well, I never have felt that way. It's just, it's a matter of best business practices. This is the way I work. Plus, I owe you a duty to go through everything that I'm going to ask you to secure in writing. We have to both have an understanding of this. In my market center in San Antonio, years ago, we had a gentleman who joined us after he retired from hockey. And hockey players are tough, make no mistake. And Brian Chance was and is a wonderful man. Anyway, he was in my class, and another agent in the office had given him a one-page buyer-tenant agreement. He said, Marilyn, he said, this is what I use. I said, there is no such thing as a one-page buyer-tenant agreement. It violated intermediary, all these other things. He said, no, he said, I have trouble with buyers signing this other agreement, this Texas Realtors one. I said, well, Brian, your buyers have never seen it, so they don't have a problem. You do. Man, that new agent, I think he was well on his way to capping. He had just been with us a very short period of time. After that, he always used our association forms because they're there to protect him.
I do have a problem with it because it is demanding what I just don't feel like it feels good.
Well, as I said, you're a profit center. You're not going to apologize for being paid. That's why brokers' fees is there. My thing is they have to know who is paying. See, that's what they have to know. All of these things that's a requirement.
Can you put a kick-out clause in special provisions that you can terminate this at any time?
Oh, absolutely. If you want a provision about terminating early, you certainly can do that. Absolutely. No problem at all. Yes.
Okay. Hi, Marilyn. Okay, I have a two-part question. One is, this paragraph, aren't we all supposed to be going through this with our clients, or do we just give it to them? Because so often when I go over it, I get that effect that Cindy just described, where they're like, oh, we have to pay. Well, it will hardly ever happen that you're going to have to pay commission, but a lot of times people just hand it to the client and then just they don't go over it. So that one's safer.
Per track, we are required to go over everything we ask someone to sign.
And then when we have an agent who wants us to show their property, whether it's a showing agent or whether it's a lead, when it's a lead, I want to go over this with them, but the agent usually says no.
Well, then you just
usually
work for
say-
free, that you represent the sellers. You would have to tell that prospect that if you're showing a listing and you don't, of this brokerage, and you don't have this agreement signed, before they cross that curb, you're going to say, remember, everything you tell me, I must tell the sellers. So please don't disclose anything to me that you don't want the sellers to know.
Thank you.
The way I do it, I just want to make sure that it's correct. I always mention that paragraph, but I give an example. And I tell my clients, like, for example, if I find a for sale by owner and they don't want to pay my commission, but it's a great deal to you, and would you be willing to pay my commission, still me to offer that option to you? They always agree. And I give them a couple of examples, like expires or FISBO especially, but I never had any problem, and I feel good that they know what they're signing.
Well, that's what they should be. They understand their commitment. Yeah. It's very important. As I said, you can cross this out. The problem is you would probably want to put something in special provisions. You may have explained it to them, but if you didn't put it in writing, it was never done, period. That's how you have to work your real estate career. Just because you said it doesn't mean the other party will ever acknowledge that you said it. It has to be in writing what you agree with on that. Okay, so earned and payable, everybody understands that too. Now, we're going to get down. Oh, and there, we're going to get to the last page. Okay. Now, protection period. I need everybody to understand this, and it's the same with the listing side too. Here's what happens. You have a buyer-tenant agreement with the buyer, and all of a sudden they didn't get the house that they wanted and that you'd put an offer in. The seller said, yay, if I didn't have to give those realtors commission, I could have sold it to you. You know, those kinds of scenarios that we get. And then the buyer comes to you and said, oh, I'm really distraught. After this episode, we're just not going to go and we're not going to look at properties anymore. I want to terminate my agreement with you. And you're thinking, really? He's living with his in-laws, and he told me from the day he met me that he can't wait to get out of there, and I have to help him find a house. So all of a sudden you're thinking, this is not adding up. But you agree to terminate, but you protect all of the properties you have ever brought to their attention, right? That's what you have to do within 10 days of it expiring or when you terminate. And you can do it on the termination agreement as well. But you have to give it in writing to them, and it has to be within 10 days. So here's what happens. Sure enough, that seller let the listing agent go too and said, oh, no, I'm not going to sell it now. Well, I'm just not getting what I want. You know what I'm saying? And they got the seller to terminate the listing with the listing broker. And then the two parties go behind the back of the brokerages and have an executed contract, and it closes in fund. That's what the protection period is for only. The moment they're free to enter into agency with another broker, they can do so, and you are not protected. I mentioned last month about named exclusions. It's a very exclusive part of any listing agreement that a seller may have named certain exclusions on your listing agreement, but if you get in that situation, you're going to need to call me because that's a very complex situation. But for the most part, once it expires or it terminates, they're free to enter into agency. And if they're in agency with another broker, you're not protected. Everybody understand that? You're only protected for the narrow part if they go behind your back and cut the brokerages out. Okay? Do you have a microphone?
How many days do you put in your contracts? I put 180.
Well, I have seen 365, I've seen 90, I've seen that. I really think it's whatever. We see a lot of different days. We see 30 days, we see 45 days, 90 days, 60 days. It's really whatever you feel is the adequate time that you might want to protect. And it can, and most of the time, I would say probably between 45 and 60 days. Because usually that takes about the same amount of time for us to find out they went behind our back and closed on the transaction. Now here's what I'm going to tell you happened. We had a buyer agent that it was that scenario. They had told him, look, I need to get out of my in-laws house. God bless you. So the agent just wasn't going to let this go, this buyer agent. They'd worked too hard for them. You know what I'm saying? It just, the listing agent could care less. They went on trying to get more listings and doing it. They could care less. They're not into that. Well, sure enough, the buyer agent had protected this property, and lo and behold, she checked the deeds every day. And she found it, and that buyer had gone back to that seller behind the backs of the brokerage and closed the transaction. She contacted the listing broker because the listing broker is where you're going to always, they're the ones who can fight that battle, just like what Michael presented. They have a better ability to fight it. And sure enough, their broker did fight it, and then the buyer agent was receiving the compensation that was supposed to be the buyer's agent, and listing agent shared it because they were able to secure it. So again, you know, it's hard to understand that you're not protected if they are free to enter into agency with another broker. So that's why I think long and hard about it. If somebody interfered with your buyer-tenant agreement, that's a violation of the code of ethics, another broker interfering with it. And a lot of times that's what we find out. Here, case in point, I'm going to tell you, I must hear this 5 times a week. Marilyn, my buyer that I've been working with for, you know, months or whatever, was at a party last weekend, and an agent friend of the person who was having the party came up to me and said, hey, if you'd work with me, I would give you part of my commission. I think that is the worst violation of all. And then that buyer came back to that buyer agent and said, I was at a party and an agent told me that I can ask for your commission. And I told the buyer, I said, well, let them know you have a signed agreement, and if you had known that that's what they wanted, that you would never have entered into an agreement with them. Once it's under contract, the broker's never going to let that contract go the way it is. The broker could appoint another agent if there's a difficulty with the existing buyer agent. But bottom line is, if somebody wants money from you, shouldn't they tell you that right up front? Personally, yeah, they should. That's not appropriate to come back to you because somebody else. And the silly thing about it is, this buyer gave that agent's card. And so the brokers handle that between themselves on something like that. So again, you know, you have to understand, you'll release somebody from the agreement, but it's going to be legitimate. It's not going to be that somebody else interfered in the agreement. Now, what county is the broker going to be paid? It's the county where the office is. Everybody understand that? I don't think so, but anyway, that's that's the way it should be. It's not the county of the property where the property is. At this point, we don't even know where the property is going to be. Now, the next thing is limitation of liability, and this is very, very important, and this has hit home to us in so many tragic ways. But neither broker nor any other broker or their associates is responsible or liable for any person's personal injuries or for any loss or damage to any person's property that is not caused by broker. What does that mean? That means as long as you didn't knock your buyer off the balcony, you're going to be fine. Do you know what I'm saying? The problem for you as a buyer's agent is you can never lead a party into a hazardous situation. You are the leader, right? Now, I'm going to tell you a couple of things. I really worry about you and your safety. And all the safety experts say you be behind your clients that are going in the property. Well, when I first got my license, I actually had to preview every property that I ever showed to a client. You don't do that today, do you? No. And therein lies what the situation might be for you. Again, you're not going to lead that buyer into a property that kind of looks disheveled, maybe something's going on, carpet pulled up on something. You know what I'm saying? You're just not. And so the best way for you is probably to ask them to remain outside. You're going to go into the property and make sure everything is in showing condition. You're going to lock the door so that they don't come in after you, right? Because you want to stay safe. And the reason I say that, unfortunately, in the last couple of years, we've had where drug paraphernalia was out on the dining room table and the kitchen counters and that type of thing. And so the buyer agent said, what should I have done? I said, you all leave that property immediately and you notify the listing agent, right? And she called the listing agent, and she did tell me the rest of the story. She said the listing agent laughed, and she said, I'm not surprised. I just want you to know you don't work with people under the influence of any drugs, right? Okay, just so everybody is clear on this. It seemed a shame that we would even have to point that kind of thing out to our clients. But again, as a buyer's agent, you're going to make sure everything is okay for you to lead the buyers in. Case in point, your buyers are not there to inspect the property. They're there to what? View it. So that means nobody gets to pull down the stairs from the garage and go up in the attic. They don't get to explore these things. One buyer agent told me last week, she says, my buyer always goes in and flushes all the toilets. I said, well, they better never do that again, and here's why I'm going to tell you that. Can they use the facilities while they're there? Absolutely not. You're going to say, let's go get in that minivan, and I'm going to drive you down to Whataburger. They don't get to use the facilities. They're there as invitees only to what? View the property. That is it. And we had a buyer's agent who they needed to use, somebody needed to use the facilities. They used it. They flushed the toilet. When the sellers got home, the house was flooded. So we're talking, you really have to make sure they understand they're there as the guests and visitors, but they don't get to, inspect the property and do those types of things. Yes, sir.
So we have a case going right now where we are the agency that was the last to show the property. It had been 7 days since the previous showing, and it had been 7 days to the next one. The house is flooded. They're saying that we turned on the pot filler. Our agent saying, hey, we were nowhere near the pot filler, but we're the last ones there. Who knows? There could have been workmen there. There could have been all kinds of things. But they are suing us right now for they feel like we touched the pot filler. But again, our agent is maintaining could not have happened. Every little thing matters. We had somebody walk on in the attic. They shouldn't have gone in the attic. They had no business going in the attic, and they fell through, broke their ankle. Maryland, 112,500.
It was more than their ankle. We were lucky they lived.
This is someone who wasn't even a person we were showing. It was someone who tagged along. So these little things do matter.
They do matter. And here's what I'm going to tell you. Who do you have permission to show the property to? Your clients only. Now, in particular, if your clients have children, it extends to them. Do you know what I'm saying? But here's what's going to happen. If they show up with an entourage, like their grandparents, their brother who's builder and all this, then nobody gets into that property until you get written permission from the listing agent that these parties can come in the property. And then you're going to tell the buyer, you're going to be responsible for any guest you invite into this property, not me. The other thing is, can you ever take your eyes off of the clients? No. So here's how it worked. I always had an entourage because I had a rally sport minivan, and they all felt, oh, this is great. She'll just be a great tour guide, and we'll all go, and grandma and grandpa will come. We'll just waste an afternoon. So anyway, what would happen is the minute they'd get out of the car, I would say, Mom and Dad will always have a hold of your hands. They can never let go of you. And if Dad wants to see the garage, we are all going to go see the garage. So they knew that they could never, ever go off on their own, because what my obligation was to the seller would be to say, I had my eyes on my clients the entire time. I will testify that we did not do this. But the minute they ask you something, did anybody go into the master bedroom closet drawers? If you cannot say, I had my eyes on them the whole time, I will testify, we never went in there. No one ever opened those drawers. That's really your obligation under this liability for you on something like that. So again, you have to, and they think your job is easy, and all we've gotten to is really through the buyer-tenant agreement. So again, it's very important that they really understand that you're going to do certain things to make sure what you're able to determine is safe for everybody to go in, watch your step, if there's a step down and those type of things. But nobody gets to inspect that property. Only those that are licensed to inspect can do that. Nobody flushes toilets. Nobody uses any of the facilities, okay? Understood? Yay. Okay, now, at the bottom of this page, on page 4, is special provisions. Notice how small it is. You can add more if you want to. If you want to describe and say that the buyer will never go directly to a listing agent's sign. They will never go on their website and put information in. They're not going to go to a builder directly, not to for sale buyer, all these different things. The other thing that I see a lot of agents adding now are your work hours. I know some of you work 24 hours a day, 7 days a week, but one agent contacted me. She said, Gary Keller told me to schedule my time off. I'm saying, did he personally tell you that? His writings are all that. If we don't schedule it, it won't, it's a matter of habit. We won't take it, and you're allowed to do that. In the event that you put the notice of when you're available and what you might require, it doesn't usually pertain once you're under contract. Do you know what I'm saying? Time is of the essence on some things, especially when you're under contract with a party. But there's nothing wrong with you to say specifically if you take Saturdays off, or you take Sundays off, or you take Friday. You know what I'm saying? You need to let them know that. They'll never be able to say they didn't know that. It's not a bad thing to kind of use that. If you need more room, you can just write up an addenda for the buyer tenant agreement on your own, and then attach it in paragraph 16 addenda. There's a little space right there where you can attach it, right there. Okay, and the last page are additional notices. No fill in the blanks, no little boxes, but there are 3 of them that are very, very important. The first one is C. Broker is not a property inspector, surveyor, engineer, environmental assessor, or compliance inspector. Clients should seek experts to render such services in any acquisition. And how many names do we give them? 3 or more. That's what the attorneys have told us, and it is held pat. When you give them only one name, they're going to say, they're going to blame you if that one name doesn't work. Please don't recommend someone that hasn't been absolutely stellar in customer service and those type of things. And so just be aware of that. Paragraph F, this is when viewing a property, client might be recorded or otherwise monitored without client's knowledge or consent. Remember, I'd mentioned knowledge or consent. Those are the 2 things that they would have to get. Additionally, consult an attorney before recording or photographing a property without owner's knowledge or consent. You cannot, and this is what we've had more agents in trouble. They went and previewed a property, took pictures in the property, and then posted it on their Facebook. I know. And one of them was standing in front of a cabinetry glass with very valuable items in it, said glowing things about the property, but the seller's friend saw it, and that's all she wrote. That agent was in serious trouble. You don't have provisions to do any of that without the seller's written permission, and we usually would obtain that through the listing agent. Everybody understand that? No casual taking pictures or anything. A lot of us might have buyers that are from out of the area, and they will say, will you tell me if this property has such and such? Well, and take a picture and send it to us. Well, you'd have to get permission to be able to do that from the listing agent. Just make sure. Do you have a microphone?
Okay, sorry. Hi, Marilyn.
Hi.
What about the clients walking around with video cameras?
They can't do it. See, it says to them. Additionally, consult an attorney before recording or photographing a property without owner's knowledge or consent.
Okay, because what I've noticed is that clients like to take pictures for their own records.
Yeah, if that's the case, you'll have to get written permission before they do it. So it's very serious.
Thank you.
You're welcome. There's a microphone. We need to work it.
But Marilyn, what if they have really crazy carpet and you want to show all your friends?
If you have really, no, sorry, you'd have to get permission to show that crazy carpet. Yeah. Is there a microphone so we can pass it up here? Oh, here's one coming over.
Just one question here, Marilyn. Back to the other issue with you being eyes on your client.
Uh-huh.
In a showing, when there's multiple people that show up.
In a showing? Yeah.
An open house.
An open house?
Let me tell you. We tell our sellers or the listing agent, if you're not in that team or part of that, to make sure everything is put away. But you literally cannot follow every person that comes through that door.
Oh, yeah, that's your obligation to the seller. You cannot have your eyes off of anybody that's invited into the seller's open house.
So are you saying then if 3 people show up, you want us to leave there? Do you mind staying outside till this other person finish seeing the
Yeah,
property?
a lot of times what I did is I'd have them sit in the living area. I'd hand them my flyer and it said, as soon as this other party is finished, my partner's upstairs with them now. As soon as they're finished, then I'm going to take you on the tour of the house. Oh, yeah. That's your obligation. Yes.
For an open house, would you post something that says no pictures or video?
You could. Absolutely. There's no problem with that. Can you have buyers that come to an open house and bring in any containers of drinks or food or anything? Any toys that their child has? Any type of backpack that's on rollers? Absolutely not. You can't do that. So it's not bad to post all that. I think that would be good information. Yes.
Some of these open houses, especially the nicer end ones, have food there for them to eat.
Yeah, well, the seller better have granted that permission in writing in the listing agreement.
Okay. The other thing is if it's staged and you have an open house and it's like 14, 16 people coming, there's just, what are you going to line them up on the sidewalk and give them a number?
Well, as I said, you have a high fiduciary duty to the seller that with these invitees, you're just not going to let them run through their property freely without somebody monitoring all
So
of
do
that.
you get this writing, say if it's a builder, do you just, in stage?
Builders were not the problem. We're talking about owner
Homeowners.
occupied property. Builders, they don't care. That's they're fine with that. But going through it with the builder would be a good thing to make sure that they are fine with that.
So do you get this in writing? What do
Now,
you do?
if you don't get it in writing, you don't have anything.
Okay, so where do we put it in writing? Just an email or?
Well, if you have a listing, you would do an amendment to the listing.
Okay, what amendment?
Yes.
I just have a couple of suggestions on open houses. I have an agent, actually she's with a different Keller office, but whenever she has like a high-end home over $1 million, we'll team up and one of us will take the second floor and one of us will take the first floor. And then the other suggestion is on signs. I would put like no going up into the attic, in a nice way, or also outside, no video or photos may be taken without, so that already they know and you don't have to look like the bad guy. So.
Okay, paragraph G. While we get them to
Can I
sign.
just ask one? You said that that's when the property is occupied. What if it's not occupied? Can they take pictures? No?
No, they can't take any pictures unless you get written permission from the listing agent. They'll contact the sellers. You don't have carte blanche. That's not your property, right? You're an invitee. That means that you're going to have to abide by that. In paragraph G, it says to reduce risk of wire fraud, clients should refrain from transmitting personal information such as bank accounts and other things. We see it here. We have it in a separate form, right? Here's what I'm going to advise you to do as buyer's agent. While this whole matter started, I represented a Keller Williams office, and the listing agent information was used to, a hacker used that because they got in the back door of the title company. So at the title company, they found out the listing agent's email address, and then they sent an email looking like it came from the listing agent saying, wire my seller's money. So that's what started this whole thing back in 2015. But here's what I'm going to tell you. There's an agent who did something that really it saved her buyers. About 2 weeks before closing, we have found that they are hitting people close to 10 days or more before closing. The hackers are. And they're kind of catching these buyers off of their game, thinking they're not supposed to wire anything. So what this agent did is twice a day for 2 weeks, she literally pestered them to death and saying, no one will ever send you wiring instructions. Do not do that. You call me, you don't return the email, you don't call the numbers on it, the whole bit, right? Twice a day. 3 days before closing, the buyer gets the email. Wire the money. But because she had literally pestered the death out of them, they called her first, and she saved them. They didn't wire money. And so it's something that's not going away. It's getting more sophisticated. And so you're really going to have to kind of pester them and let them know. Remember, no one will send you wiring instructions. No one. Be real specific. Don't call them on the email or don't respond on that. Okay, so now that's the buyer tenant agreement. Now, down at the bottom, who gets to sign this? The clients, the buyers get to sign and date it, and you get to sign and date it. Who is the broker's printed name? It's not Michael Bozart. There you go. It's one of the DBAs that we have for this market center, and the license number for that brokerage, not an individual, okay? It's not your license number on something like that. Okie dokie, now we're going to get back to the PowerPoint. Whew. Okay, next. We'll get as far as we can today before you have burnout. And because again, the more questions you ask, the better it is. Everybody needs clarity on this. This is not easy for just everybody to understand all what's going on. Okay, so you represent a buyer who's interested in a foreclosure. What should your buyer know in writing? Well, they should know that this entity is exempt under the Texas Property Code for any disclosures of condition of property. And truthfully, they don't know anything, really. That's how it's proven, is that they don't have any knowledge of the property that they acquired. We're not talking about an investor that bought a foreclosure property. They are not exempt. We're talking about the actual foreclosure, the lien holder entity. So what does your buyer have to know? Many times, these entities have their own addenda that they attach to the contract, to the promulgated form. And it usually takes away some of the provisions a buyer may have. For instance, if it says you don't get the termination option, but it will give you an inspection period, that means that the buyer has to understand you're going to be doing quite a few inspections because you don't have anything to rely upon the sellers disclosing anything to you. And oh, by the way, if you decide you don't want the property because there's too much, you don't get to walk away. You always have to ask for it. Only those foreclosure entities will be the ones to say, look, we won't do all these repairs. We'll terminate the contract and give you your earnest money back. But the buyer does not have the unrestricted right to terminate, which is what every buyer needs to have, right? But sometimes they want a foreclosed property. So again, you'll have to tell them in writing about making sure that they're going to do more than one type of inspection. They're going to really inspect the property very well, and that's going to cost them what? Money. Now, they can make a stupid decision, but you are never going to deviate from it. Do you know what I'm saying? You're going to put that in writing. Yes?
15 years ago, I sold a foreclosure, and they gave me some kind of deed that was not the normal deed.
It's special.
Why is that?
Because they don't want to give, they don't want to rely upon the history of the property. They only know it from the time they acquired it back through foreclosure to when they sell it to the next party.
So do you need to explain that to the buyer?
Yeah, any buyer who's going to get a special warranty deed, you're going to recommend that that not be their case. And if they want that, they're going to have to do some research, and that'll be with the title company. They'll probably talk to the escrow officer. But we would only recommend what? General. It's in the promulgated form. You know what I'm saying?
I didn't know. I got to closing and I didn't know, and the property has already been sold again. I sold it again. But what?
The buyer just needs to do their research on it and then make a decision. Some buyers feel real comfortable with the special, but they're going to have to do their research. But we're never going to advise anything different than general.
Okay, so how do they do, you talking about the back history on the
Yeah,
house?
there's nothing. They only warrant from the time they acquired it in foreclosure to the next time they sell it to the next buyer.
So there could be a lien on it?
Could be all sorts of issues, correct. We don't know that. See, when it's a special, that's what happens. Okay. But those entities don't want any liability, so they're not going to say, we're going to, go backwards and guarantee all that and provide a general. They're not going to do that. Short sale. Okay, have any of you ever sold a short sale? Yeah. Well, let me tell you, the next word is called distressed. owner, next two words, distressed owner. Those are legal terms. These people haven't been paying their mortgage or taxes, whatever. They're going to lose the property. They are very distressed. These are people who don't make good decisions. So your buyer would have to know that, you know, while you may have a contract with this seller, it is contingent upon lien holder's approval. In other words, you'll have a binding contract between the parties, but it is in limbo until the lien holders provide in writing that they have approved this sale to go forward. Okay, so the lien holders, a third party, has to determine if this contract's going to go forward. What your buyer has to understand is that these are very distressed. If they didn't pay their mortgage, they didn't maintain the property. Everybody understand that? Big time. And that's what your buyer literally needs to hear from you, because they're going to have to do all sorts of inspections too, more than just the truck inspection. If the truck inspector says you need to do this, you're going to need to do that. That is what you're going to need to do. The other thing I'm going to tell you, the rest of the sad story on these distress sales. The buyer agent took the buyer on a final walkthrough the day before closing. Sellers had already gone, right? So the buyer agent did that. They went to closing the next day. When the buyer got to the property, the seller had removed all the fixtures, all the plumbing fixtures, all the lighting fixtures, and the buyer walks in and it's all gone. So I'm going to tell you, this hasn't just happened once. We've had reverse osmosis removed and sold. You know what I'm saying? That's a distressed owner. The poor listing broker is not going to be liable for it because they didn't know the seller did it anyway. So my advice to you, if you represent a buyer that is under a short sale and they're getting ready to close, they're going to see that property moments before they close. Okay, just so you understand, we've had to deal with way too many issues because that's what that distressed seller did. And you know, we asked the listing agent, could they bring it back? And the seller laughs. They said, I already sold it. And that's how we have been experienced with that. And again, that distressed owner hasn't been maintaining the property. So there's lots of issues from an inspection standpoint. Yes?
I sold another house back 10 years ago, and I always walked through right before close. I mean, the day before closing. Mm-hmm. So I walked in this house, and I was a new agent, and this was the day before closing, and I represented the buyer. We walked in, and we stepped on the carpet. The whole house had flooded. The people that had moved out of the house, the
washing machine?
Mm-hmm,
Yeah, we've had that lots.
The washing machine?
Yeah.
So I never, ever close a house that I don't go from the house to the title company. Ever.
I know. And it's unfortunate, you newer agents to the business, these are the words of wisdom from somebody who's been through certain situations that now they absolutely understand we're never going to have this situation again. We have that a lot. Relocation companies, you know, they hire a big mover to come in and move the sellers, and they pack up everything, including the remote controls that were in the kitchen, you know, all these different things that happen. But this one has proven that it's been really sad. And the worst part was the buyer wouldn't let this go. The one with all the fixtures gone, that was entirely different. But this was the reverse osmosis. This buyer wouldn't let it go. They were pestering the broker and the buyer agent 1 to 2 times a day. And finally, they just said, uncle, and they participated and they gave money for a new one because they needed that buyer to go away. It wasn't their problem, but you understand you can only be hounded so much before you cry uncle. And it was unfortunate. Flipped property. This is investor owned. Your buyer needs to know this is serious for you. Very serious. Because here's what I'm going to tell you has been our experience. There is no proper disclosure. Half of them purposely are fraudulent on their seller's disclosure. The other half are just incredibly negligent in completing it. So it's never a good scenario for your buyer. Very few flip properties, and a lot of these flip properties, an agent is also a principal. And that's a horrible violation. Agents are held to a much higher standard. But on these investor-owned properties, when they have rehabbed them or flipped them and done things, they have considerable information about the property. And for them to say no, it's just ridiculous. But you know how these buyers are. But I really want this property, Marilyn. Well, you're going to advise them. You're going to have every kind of test run. You're going to get a hydrostatic test, all the different tests that are going to be necessary. Because again, that's our experience. We have not had good experience when we have had litigation involving a flipped property. And you would think they'd know a lot more of it because they ripped it up and did all these things. The one thing that I'm going to tell you is so critical, and I did this last year in one of my sessions. I told you that when an individual has rehabbed the property, they're subject to a lot of things that builders are subject to. And so what would happen for your buyers if they go into this, they probably want to add a statement in special provisions of the contract stating that the seller will provide all release of liens from any vendor and all vendors that ever did work on this property. These releases must be provided prior to closing and funding. Now, the reason for that is we've had too many situations where the investor got crosswise, didn't pay some vendors, didn't turn up when title did their search. None of those liens and judgments were on that property, right? So they closed and funded it. And within the next month is exactly when those mechanic liens appear on that property. And now it's your buyer's problem. But your buyer is going to blame who? You got it. So it's real important that if you don't know how to do all those things, that should be something that the buyers will think long and hard, because it sometimes falls through the gap. It's not there, but your buyer would be responsible for all of that, and they're going to pull you into the matter.
Isn't it the title company responsible to
I told you, title company ran it and they weren't there. And then those mechanic liens appeared after it closed and funded.
But
title company,
can we upload it to that?
if it's not filed and recorded, the title companies won't know it. Yeah. So it's not the title company's problem.
That's your question. Can you possibly upload this form so that we get that sign?
What form?
That all these liens going to be cleared?
You're
An
gonna,
amendment that we can get this signed, like,
you can put it in the contract. Your buyers will do that once you've advised them to do that. They'll give you the language that they want. It's a material fact, a business statement, and it can go in special provisions, or that you can do it in an amendment. Yes. Where's your microphone?
Here's
Okay.
my microphone. So, what if they give you all the contractors and they leave off one? I mean, how do you?
Well, then I think the buyers can get a lawyer. They would contractually be bound to it because that statement said seller will, and if the seller failed to do something, a lawyer representing the buyers would be able to probably go after the seller.
So is this on any fixed up house that?
Anything that's flipped property, anybody's done work. What we have found, unfortunately, is some of these investors did electrical work themselves. They did plumbing work. They did HVAC work. All these things that require a license in the state of Texas. And it wasn't uncovered until it was after the transaction closed and funded. See, the buyer really needs to do a lot of vetting during their termination option to determine who all came on the property, who all did this work.
But isn't this with any property that we sell? I mean, you know, a lot of sellers do things 10 years ago that they did themselves and they don't remember.
Well, listing agents, you can do something on your own property, but in this situation, when they're holding out that they've totally remodeled or updated, the consumer is thinking what? You didn't do it yourself. You hired those that were licensed to do the work, those kind of things. So it's a real cautionary tale that you will give your buyer in writing so that they make sure that they get all that taken care of.
Wouldn't you put it in the contract, Marilyn, that all repairs were done with a licensed person?
Well, that would probably need to be something that the buyer would want to know prior to offer.
So you
Because,
get it, you do an email or something?
yeah, and it comes from the seller, that the seller's made the representation.
Then would you put in the contract that all liens have been paid?
Yeah, well, seller will provide all release of liens by any vendor that did any work on this property prior to closing and funding. That's what you'd want to do. Yes.
Yes, I have a question. It's kind of related, but it's about come on. It's about the inspection. So the city inspection. I had a client who was buying a new construction like a year ago, and we were about to close. We were final walkthrough, and when we were there, she, thanks to God, was a super high C, and she asked like a million questions. I was there to make sure that everything was gonna go forward properly. She was super scared, and we find out at final walkthrough, before she just signed the final walkthrough, we were going to closing, that actually the property did not pass the state inspection, so she could, not leaving the house until it would pass it, because it was unlivable. But they were ready, and it was a big builder, it wasn't like somebody small, and they were ready to close on the property. So that's something that it's important to take in consideration.
Yeah, the buyer needs to be advised to consult a real estate attorney to assist them with this matter. You're not going to go to closing and funding if something is outstanding on something like that.
That's exactly what I did. I postponed closing because the house was not ready, because it was unlivable, so it was easy to postpone.
Oh, yes.
In the documents, it says that the seller should provide any inspections that may have been done previously that they have
In
knowledge of.
section 10 of the seller's
Right.
disclosure, it says any reports that they've
Right,
received.
but it doesn't say anything about if any major work was done.
Yeah,
Okay.
the seller is required to disclose the condition of the property based on right now. So it doesn't say if you've ever done work on the property, tell me.
Okay.
Listing agents, that's what I've told you about. That's your job as a listing agent, and a good listing agent will turn that up. I told you about the one where the sellers had a Four Seasons room put on the back of the house. It was an absolutely gorgeous house, and I knew it was going to sell fast. Turns out the bank that financed that Four Seasons home, that improvement, had closed. And so the release of lien, we couldn't acquire the release of lien because it had shut down. And for the auditors to be able, the bank auditors to be able to go in and try and find those documents so that they could close and fund, it was a big delay. It taught me then that I'm going to look with eagle eyes when I go to my seller's property so that I can ask them those questions. Have you ever had a contractor do any work on your property? Because a lot of times people think they've pulled all the proper permits that are required, and that's not necessarily the case. You know what I'm saying? They've liked the work and all this, but they didn't understand the detail until it went time for them to sell the property to somebody else. Yes?
Just getting back to the comment that I just made, flippers, they also have to pass the state inspection or whatever inspection with the city and stuff. So I have no idea how that inspection looks like, and how can we advise our clients if to make sure that the house actually did pass the inspection and it is livable?
Well, you're going to ask the builder point blank. The builder's going to answer those questions.
But what about an investor? What about if it's according to the remodeling that they're doing, they have to pass the city too?
Well, in paragraph 8, section 8 of the seller's disclosure, there's a question, and there's been horrible lawsuits over it when the seller said they've acquired all the permits and they didn't. There's lots of things that will get them on something like that, on resale type of thing. Yes?
Sorry about going again, but do they have to get a new occupancy permit if they flip the house, or are they just?
It would be subject to where that property is located, what the ordinances are. We couldn't answer that. The seller needs to have known that. Buyers can look at it. Most of the permitting has been online now for the last 10 years or so, so anybody can go and see if a permit was pulled and the status of it. It's a public record. Estate property. No seller's disclosure is required, but in the event that the heirs or the executors of the estate have material information and knowledge. Everybody is required to disclose any material information they have about the property. They're not going to be exempt because the statute says it's an estate sale. And that's an important part of it. And you know what happens a lot of times is that the parties are saying, well, I've lived away from the home, I haven't been in the home in years and all that, but they know if the home flooded. Do you think that's pretty important? Oh, big time, especially here. So that's what I'm trying to say. There's some material information. My mother will be 100 years old in a couple of months. I know, there has never been anything done on her property that she lived in until she was 98 years old in the middle of nowhere. It's called Center Point, Texas. That either I didn't arrange and pay for or my brother did. So if we were heirs to the property, we would have to disclose everything because we absolutely knew things about the property, because that's how we helped our mother. So again, it's really hard for somebody to understand that. I am going to tell you there was a horrible situation with a property in San Antonio area. The owner of the property committed suicide, and it was in the front page because it had been going on with an ongoing dispute for months. Front page in the news, right? And then he took his life. So when his sister came in from out of state to handle her brother's estate, the listing agent called me and she said, Marilyn, what do we do? I said, you know, somebody's going to buy this property that's not from San Antonio. They move in the property, and guess who's going to tell them everything that they think that it's the next door neighbor? And so the sister was on the phone with us on a conference call, and she says, I'm going to disclose everything. In fact, the agent said I should probably do a listing, pre-listing inspection. I said, that's a great thing because you don't know the condition of the property, and you might want to address this and have the estate address this. And so, again, it is very, very important that nobody gets to hide or conceal any material information they have about the condition of the property. Yes?
Tell the group this. I had a listing about 3 months ago, right, Marilyn? And the mother had died, and the son was an attorney, a sharp guy. And the other brother was living in the house with the mother. So they're longtime clients, and they wanted me to sell the house. And the attorney said, I'm not filling out a seller's disclosure. My brother's not filling out a seller's disclosure. And Marilyn said, don't take the house. And it broke my heart, but I said, I can't do it without a seller's disclosure. And they hired another agent, but they just bought a big house for me. But I did not sell, I gave up that deal.
Well, we had a horrible lawsuit that involved two of the Keller Williams offices here about 10 years ago. And here's what happened. It was, the brother was the executor of the estate. The house was over in an area where it was quite a few acres, and it was going to be used as a commercial endeavor. They were going to put their landscaping business there. Well, the seller, there was a house, the original house that his sister had lived in, had no windows, no doors, no AC. It was really just a shell, right? So the attorney for the estate said, oh, you don't need to complete a seller's disclosure, right? Had the property flooded? Yeah, more than once. Was it lead-based paint? Yeah, it was built before 1978. So the attorney for the estate had advised them. Here's what happened. The son, the brother of the owner was the executor. His nephew, the son of the owner, was at a bar just down the street and told all these things to some people that were sitting there on these bar stools. And they found out that the property had flooded, all these things. They wound up suing. Yep. So there's always that kind of thing. The brother, the son. So all these people who have knowledge, you never know who's going to pop off and say something, and then somebody overhears it, and now it gives all of them pause for it. So We make decisions because we're not going to do certain things because that's too much of a risk for us as that. Okay, you want to use the microphone?
Yeah. I have a quick question. I remember your last class with the sellers. You were telling us about the seller's disclosure and this section 8 at the bottom regarding the water conservation district. So with my listing, I gave him the map and everything. But if we're talking from the buyer's side, most agents tick no because they don't know that all homes in Harris County are in this water conservation district. And I only knew that because I came to your class. So from the buyer's side, if you receive that seller's disclosure from the seller and it's tick no, but otherwise,
you're going to give them that same map.
You give the buyers the map.
You represent the buyer. Whatever you know, your buyers know. So if the seller has clicked no when we know for a fact it is yes, your buyers are going to know that because you're going to give them the map. And then they're going to do their due diligence during their termination option to determine if they want to go forward or what does this mean, how is the taxing authority, and those type of things.
Okay, so you don't have to tell the listing agent because they probably don't know.
Usually, we don't ever instruct the other agent, the other brokerage's agents. We don't usually do those things. You could maybe do it as an FYI if you want to be, but sometimes they'll get their feelings. They'll be offended by something like that. Okay, the next one real quick is Stucco Houses. Okay. Here's the deal. If you have a buyer who buys a stucco house, you are going to put in real bold letters in that special provisions of that tenant agreement that if you purchase a stucco home, you will have to have it inspected by a stucco specialist. No ifs, ands, or buts. And the reason for that is it is an invasive test. The sellers have to agree to it in writing, and it can. We've never had a small dollar amount on anything like this. Case in point, we had a huge one with this office where a buyer represented, a buyer's agent represented a buyer, and the buyer bought this house and it had stucco. And what we find with stucco homes is while there may not have the appearance of any cracks, something that's really obvious, where we have issues is when things are not caulked and sealed properly around windows, doors, and balconies. We have some builders that have been involved in class action lawsuits over their stucco applications on the home. So again, it's one of those things, the buyer can choose not to do it, but once you tell them in writing to do it, it's going to be pretty hard for them to say you didn't advise me properly. So everybody understand that. Stucco homes are just, as I said, we can never have an exception that this stucco home is fine. And that property, most of that was lack of sealant around the windows and the doors and the balcony. And all of those in that little project, there were 6 homes in there. They all had it, all subject to it. Yes.
So I live in Bel Air, and these homes are not cheap. And so this home was built by this diagonal from me. And the people moved out. They kept saying they had an issue. They didn't know anything about it. Anyway, they moved out. The second people moved in, it was stucco. They took the front half of 2 stories off the house. You could see completely through everything because of one leak. That they let it go. I guess all these people let it go. Anyway, it turned into a nightmare. They didn't sue, but I'm surprised because you could just see through the whole house. It was stucco.
Yeah, the worst ones have been where the roof did not truncate properly, and the roof, the drip line went dripping in between the stucco and the walls, and that is over a period of time. It literally destroys the entire property. People have no idea. So it's one of those things. You'll never, ever not advise them in writing to have a stucco specialist. And we're not talking about somebody who put a little sign on their truck and said, I'm a stucco guy. We're talking about somebody that is reputable, that has a great reputation and does this. That usually requires the buyer to have a very long termination option period because it's hard to get them scheduled and it's hard to get that turnaround on the report. So the buyer has to know what? You might have to have a 20-day termination option to get all of this done. That is exactly the truth of what you'll be telling the buyers on something like that. Yes?
Sorry, Marilyn, you said put that in special provisions in the buyer rep agreement?
Correct. Yeah. Anything you want to bring attention to them and they've signed it early on, that's where you're going to do it. Next month when we go through the rest of this, I'll show you on the general information and notice to buyers and sellers where you can highlight things and have them initial it and that kind of thing that might bring their attention. But there's nothing wrong with bringing it to their attention from the beginning, because that's one of the risks that they're going to have to take on something like that. Flooded properties. Okay. Here's what these, again, the poor buyer is going to probably have a very long termination option. They have to get in writing from the seller, and it should be attached to all the seller's disclosures that the parties are going to present. All of the mold remediation and the clear report that comes after there's been remediation of mold. Because what happens on flooded properties, if there's been water, there's been mold. Always. And so what would happen is that if the seller has done the remediation, the buyer needs to see it in writing, and they really need to understand that they're now going to have to hire a mold assessor to come out and determine if it was done properly, if it was remediated properly and they got all of it. We have tremendously difficult times with these transactions because the buyers delay getting their flood insurance and all of their insurance, right? They wait. You have to have that during your termination option. No ifs, ands, or buts, period. That has become serious. Let me tell you what happened. It was about 45 days, almost 2 months, when a buyer agent gets called. And the buyer says, oh, I just got a notice from FEMA. I paid for the flood insurance at closing, but they canceled it because this property flooded 3 times and FEMA won't insure it. See, these are the kinds of things your buyer has to get straight with their insurance agent. That insurance agent should be doing all of the legwork for your buyer to get all of that cleared up. That is so dangerous for somebody to acquire a property that flooded 3 times and now they can't even get flood insurance through FEMA. Okay. Again, these are not your typical transactions. They're going to be long termination options for the buyers, and they're going to have to pay a lot more money for specialized inspections, but the buyer needs to do their due diligence. In the contract, if the truck inspector says you need to get a stucco specialist to inspect the property, or you need to have a mold remediator come, anything that the truck inspector notates what the buyer needs to do, the buyer has a duty at that point to further investigate and turn up any defects. It's on the buyer. They can't just wait. And so that's what's so serious about this now, and why as buyer's agents we really have to kind of bring that all together and let them understand that. Yes?
Do you, does the buyer should get flood insurance prior to closing?
Well, they need to get it done during their termination option.
Okay.
That's what I'm saying. They have to do this due diligence and find out, you need to uncover for me, insurance agent, how many times did this property flood? I don't want FEMA to come and cancel on it if I'm going to do it. Do you know what I'm saying? That's their fiduciary duty when they're the insurance agent for them, and they need to really do that. But they need to do it during the termination option. Yes?
Do they have, after they come and say, okay, you have mold, do they have a certain period of time they have to remediate in and then have the inspector come back?
Well, what happens is the mold assessor comes and determines, does the testing. The labs are only a few labs in the United States, so it takes time to come back. Then once the lab results come back, the mold assessor writes a protocol. Then it gets transferred. That protocol is handled by a mold remediator. They're the ones who are going to do the remediation. Once they're completed with the remediation based on that protocol, then the mold assessor has to come back and say, you did the right thing, there's an all clear. So it's a very protracted process because of those parts of it.
What if a list was never given and none of the homeowner or no one knew anything about A, B, and C? They just said, you have it, and then clean it up, basically. And this is from a U.S. lab. I mean, just in the dark.
Well, if the seller disclosed to a prospective buyer, this house has mold, here's the report, and then the buyer would be faced with having to do their due diligence. But a seller needs to disclose everything that they know about the property.
Right, but the guy just didn't say anything. This was for as a realtor, and it just went on and never said anything.
Well, that's a shame on them. It's not right. Okay, unimproved property, raw land. This is a huge risk for you. We have had, most of the E&O policies don't even cover these types of transactions because they're laden with issues about buyers saying, I want a future use of the property, now I can't do it. Do you know what I'm saying? These are difficult. There will never ever be a buyer buying any unimproved property that they do not have a termination option. During that termination option, they are going to be spending weeks determining, can I use the property in the manner I want, checking all the requirements, the ordinances that might affect it, permits, everything. It's involved. And there is no buyer that's ever going to say, well, I'm going to be able to build on my dream home. Oh, really? You're going to have to get the architect out there, the builder, and all the permitting and all the requirements before you leave your termination option. You don't get to do this after you close and fund. And so this is a really serious matter. Unimproved property causes agents quite a bit of problem on something like that. If you're not really familiar with this type of transaction, you might want to pass that along to somebody who's done that type of thing, because it's a more involved type of transaction. Even with commercial acquisitions, those buyers use their feasibility period to do all of these different types of things, environmental reports. It's a very involved process. It doesn't happen quickly, and it doesn't happen in 10 days or 14 days that they're able to do their due diligence. Sometimes it's 30 or 45 days on something like that. Okay, if there is a pool, the pool inspection is different than a leak detection for the pool. That's a very specialized part of the type of business. It's not done by all those people who